Let me just say I'm very happy to discuss one of my favorite topics, diversity, and what it means in the workplace and what it means to treat your clients and be woke, as they say these days. So before I get into the malpractice claims talk, I want to talk about something we've been seeing recently. I'm a claims prevention lawyer at LawPro, and we have been seeing this issue currently now before real estate lawyers. It's on its way in the courts now. But however it turns out in the courts, it's something you can look for and something you can avoid. So this is what's happening. Real estate lawyer is doing some research for a client that wants to sell the property. Could be residential, it could be commercial, it doesn't matter. In doing so, the lawyer discovers, oh, there's a lien on the property, right? You guys have all done this many times before. And this lien is registered by the CRA. So what does the lawyer do? You want to investigate that, you send a letter to the CRA and say, I've discovered there's a lien here, tell me how much it is, we want to sell the property, and we want to discharge the lien. And so, letter goes out, CRA sends a reply letter. This reply letter is interesting. It comes because it comes with two letters. The first letter is written in plain English and says, thanks for the inquiry. Your lien is in the amount of, for example, $30,000. Pay it promptly at closing and so on, and it's all good. It doesn't say it's all good, by the way. That's just me. But it's a plain English letter that says you owe your client owes this amount, and that has to be paid. It comes with a second piece called a requirement to pay, which is a form letter and written in tiny, tiny print. The biggest print you're going to see there is 9 points, 8-point print, okay? And it's going to say a bunch of things in legalese, such as, your client is required to pay this and this, or actually, never mind, it doesn't say your client is required to pay. That's why it's confusing. It has a bunch of paragraphs about the requirements, and then it says this, but do not pay in the amount of, for example, $150,000. So what are your thoughts when you see that? Your first thought might be, well, no problem. I'm going to pay the $30,000 lien, and don't worry about the $150,000. They don't want me to pay that. Or sorry, do not pay in excess of that amount. Okay. Your second thought, if you're a more experienced lawyer and you've seen this before, is, oh, there's something having to do with $150,000 here. What is this number? I should go and figure out what this number is. So now you have a couple routes to take. You can talk to your client. What's this number about? And your client can say, oh, that's right. I owe the CRA $150,000, which means for you, the lawyer, when you sell this piece of property, not only do you have to pay the $30,000 owed, and that is the lien, but you also have to pay the rest of the $150,000 from the proceeds to discharge everything. Or here's what happens if you don't do that. Some lawyers saw this and they said, okay, I'm just going to pay the $30,000 lien. The CRA then has gone after the lawyer for the rest of the $150,000. That's why it's before the courts. And the lawyer then, they're trying to collect from us, right? Not too unusual for individuals to try and come after another pocket of money, but you can avoid all of this. All you have to do is look at the requirement to pay, which has a number, and look at the letter that says the lien is in this amount, which has a number, and make sure those numbers are the same. And if they're not the same, investigate what that's about and take appropriate steps. Okay, so I just want to talk to you about that because we're seeing that. Okay, now let's talk about malpractice claims. Generally speaking, in regards to diversity and malpractice claims, there are two reasons why claims come. The first is insensitivity to the culture. The second is oversensitivity to the culture. The lawyer wants to adopt the way that the lawyer works to the way that the client lives and works, to the point where it goes against the rules. Like you want to accommodate that client so badly that you've taken a step more than you should have. And I'll give you an example here. We've got 4 examples. The first one, and this is in the context of a lawsuit, but we can easily think of real estate examples. These are real malpractice claims. In a personal injury lawsuit, they come to the settlement, they have the settlement discussions, they finally arrive at a number they want between the client and the other side. Now, there are 2 clients. The one is the father of a family, and the father was in the accident. And the other client is the father's daughter, who was also in the accident. In this culture, the father is the one that is the head of the family. The father is the one that says, we're going to do this as a family, we're going to do this as a family, and so on. And so the father decides what happens. And so what this lawyer did when the settlement number was given was seek instructions from the father. Are you okay with this settlement? Father says, yeah, sure, sounds good. And the lawyer goes on, says to the other side, we have a settlement. What's the mistake here? The lawyer has 2 clients. The lawyer should have talked to the daughter. So what happened was when the release papers came, the daughter says, you never asked me if I want to settle this for this amount, because I don't. And now we've settled for too little, and I'm going to come after you, lawyer, for the rest of the money. You should have gotten instructions from me. So that's an example where the lawyer has to be cognizant of the culture and what it means against the rules. You can't just say to yourself, oh, this is how they live and how they work, so I'm going to do that. You have to explain to your clients, I have an obligation to each of you, each of my clients, to listen to you and to get instructions from you. In real estate, there are obvious examples. You're negotiating a deal, you have more than one client, you want to make sure you get instructions from each of the clients so that everyone agrees at that final number, and so on. Okay? So let's do another example here. Now this is a community where, now this time the client belongs in a community where they don't like to write down deals. So they'll say, you know what, this is good, and we will agree to this, and I will pay you this amount for this property, and so on. And you have my word. And in this community, giving your word is enough. The lawyer wants to accommodate that. The lawyer then proceeds with a whole bunch of commercial and real estate transactions, mortgages, everything, and nothing is recorded in the trust accounts. Cash moves in and out, nothing is recorded. This is a recipe for disaster. Now what happened here was the Law Society stepped in and investigated the issue, and it turns out nothing fraudulent happened. But again, there's the risk, right? That the lawyer tries to accommodate the culture beyond what the lawyer is required to do, especially when it has to do with trust accounting. And so in this case, there was no malpractice claim that cost us, but it was close call. Okay. The second kind, another kind of scenario that we see has to do with you as a racialized or as a diverse lawyer. If you are having problems trying to fit into this culture, trying to get a job, trying to get business, the inclination may be to team up with someone, which is often a good idea. And so what happened here was this female lawyer in her 50s came. Imagine you go to law school, you get your degree, and you come here, and you're having a really hard time making a go of it. She meets a paralegal from the same community. And so they get along really well. She's charmed by this paralegal, and they decide to group together and make a team. Clients start coming in by the fistful, and transactions in the hundreds of thousands are coming in. And then the paralegal says, you know what? There are so many of these transactions, and they're really my transactions because I'm bringing them in. Why don't you give me your turn in? And then I will take care of all of these transactions. And you don't worry about it. You just sit back and everything will be fine. And so what happens? Turns out these transactions were fraudulent. And of course, the lawyer should never, ever give anyone the turn it other than yourself, right? And what happened here is very unfortunate. The lawyer was ultimately disbarred and can no longer practice as a lawyer. So imagine coming here as a lawyer in your 50s, trying to make a go of it, so happy and so proud, but you make a mistake like that, it can cost you your license. So that's another aspect where we see the claims coming from the diversity angle. Another one is obvious, and I wish it didn't need to be said. In this case, a lawyer was appearing before a hearing for a racialized client, and during the proceeding, the lawyer starts to give submissions. And at the break, the lawyer makes an off-color joke about the client's racial makeup. Client's not happy. The client then obviously fires the lawyer, sues for defamation, and to make it all worse, all of this is recorded by the court because the mics never turn off. Okay? I don't have to say this to you guys, but it's obvious. You want to respect people's cultural diversity and not make such humor. Just because you think it's funny doesn't mean that in sensitive contexts like this that it's worth making that joke. Okay, the last scenario I have has to do with a lawyer that wanted to accommodate the Sharia mortgage system. And in this system, what happens is loan transactions can be done, but interest cannot be collected. And so the interest was characterized as rent. And what happened was the mortgage went into default. And the bank came and said, how about the interest? And the client said, I don't owe any interest. I've been paying rent. So what does the lawyer have to do here? The lawyer needs to communicate with the client. I understand that you don't want to pay interest, but the bank requires that this be done. So if you want this transaction to go through, this is the only way it can be characterized. Or the lawyer can go to the bank and try to convince the bank to collect the interest as rent, whatever those consequences may mean. But that discussion has to be had for the transaction to make sense, so that no one is confused as something happens down the line. Again, trying to accommodate that other culture can come back at you if you've gone too far. Okay. I'm going to give some tips here with the rest of my time here to talk about cultural competence and how you can get along with people from different cultures. Cultural competence is just how you connect with people from different cultures. We've all sat in a room, and it doesn't even have to be someone from a different culture. And we've met someone that we don't like, and we don't know why. Is it the way the person looks, the way the person talks, their pitch? I don't know. But the studies have shown you can connect with people that are totally different from you, people that you have an instinctive gut dislike for. You can improve that simply by trying to match their tone of voice. So, if they speak in a higher voice like that, you can go up a little bit higher, or by how loudly they're speaking. We've all met people who are less loud, and we've all met others that are more loud. And all you have to do is expand your range of communication to more closely match. Pace of speech is another one. I had a great mentor, and he always spoke very slowly. Every word is significant. But you can also do that. You can slow yourself down. Or you can speed up as someone's speaking quickly, right? And it's incredible if you try this with your clients, how quickly you'll see the results come. So studies have shown trying to match all of these, body language, tone of voice, pace of speech, can really help. And of course, vocabulary. Now vocabulary, yes, matching can help, but you might end up being too patronizing. All I will say with vocabulary from personal experience is always speak simply. Always use the base, easiest language that you can. Okay. So those are some more tips. And let's talk about cultural competency in the context of power structures. in some cultures, for example, and there's a great example from Malcolm Gladwell in I think his book, The Tipping Point, where some cultures will defer to authority because they all live in the same culture. And so what happens is they speak always very subtly. And I'll give you an example of this. And they did a study of airplane pilots. And so the pilot's going along and the fuel is low. In this Western culture, which is known as a low hierarchy culture, low hierarchy because people lower in the system are free to speak up and are often rewarded by speaking up. In this culture, if the pilot is going very fast and you're the co-pilot and you're losing fuel, what are you going to say? We're losing fuel. We need to land. But in other cultures, it's different. It's, we may not be able to reach the airport at this rate of speed. It's, how long is it going to take us to get there again? It's, what's our destination here? Very, very subtle cues, which when they did studies like this, they discovered why, for example, in these cultures, there were more plane crashes because the pilot falls asleep at the wheel and the co-pilot isn't able to bring up the issue. You can only subtly hint. And by the way, they had recordings of the communication between co-pilot and pilot in the black box. The culture is so ingrained that it was only until they crashed that the co-pilot said, we're low on fuel. When you speak with your clients, and your client is from such a culture, and you are, for example, from the Western low hierarchy culture, ensure that when they're saying something to you which has no meaning for you because it's so subtle, that you're listening, that you understand. That when you're there with the father and the daughter says, and you say, daughter, what do you think about the settlement? And she says, could I have some tea? What does that mean? It means take her out into a separate room and ask open-ended questions. What do you think of this settlement versus should we take this settlement? Right? How are you feeling about this? How do you want to approach this issue? Open-ended questions. Right? It all depends on the culture. People communicate differently depending on where they're from. So that's an example of low hierarchy, high hierarchy cultures. Okay. Okay. Another one is group versus individual focus. So there are cultures where the focus is on the group and how well the group is doing. And others where it's on each of us as individuals. I think we can guess. In this culture, Western culture, it's the individual that gets the focus. You know, it's the guy that goes up the plate and hits the home run that gets all the goodness, all the reward. But in other cultures, it's about the group, and they are more concerned in those cultures to speak to values that promote the group. If you're in a law firm and you happen to belong to this kind of a culture, then you might be inclined to go along with whatever is going on in that culture, whatever is going on at that law firm, right? If you see something wrong that's happening, you might not want to speak up. But it's still your duty to speak up if something has gone wrong, right? Similarly, if it's the other side, everyone gets to be an individual, but you come from a culture where it was a group environment, and you see, for example, an individual that is working improperly, or someone senior to you that is doing something wrong, and you don't speak up about it because you come from this culture where, okay, this is the culture that I'm supposed to be in. I'm supposed to support my supervisor, my senior lawyer, and so on, even though I see something is wrong, right? It's up to you to do something about it. So I ask all of you to step out from those cultures, to at the very least identify where you are, and then identify those around you, and then think about how you want to react to it. Think about whether that plane's going to crash because you didn't say you're out of fuel, because you were too subtle about it. Right? Think about your clients and how they feel when they're talking to you, and how direct or indirectly they might be speaking to you. So thank you very much. That's my presentation. I've got a few minutes to take questions, if any. Do you got some for me, Chris? Oh, okay. Okay. Does anyone have any questions? This is just a notice. Yes?
Legal context, when you have the client coming in with the parents usually, and the parents taking over, what's suggested?
The question is, what happens in a family law context when the parents are doing all the talking, but not the kids? Is that it? Are the kids minors?
No.
And the kids are adults?
Younger adults.
Okay, the kids are adults. And certainly you guys would see this too when you have, for example, a father and son come and get a business or get a property and so on. If you suspect that there is an issue there with a young person strongly disagrees or might strongly disagree, all you have to do, and this happens in the estate law context all the time, is put this person in another room and ask them, what do you think about this? Are you getting pressure? Is your father saying this, but you don't want to do this? Because I want you to know, you can say no. You're my client. You are the other property owner here. This is your name on this property, right? So you can have that conversation with them. Just pull them aside, you know? In estate law, the elder parent comes in with the younger child who might be unduly influencing the elder parent. You take that parent aside into a different room. Tell me what's going on. So that's my recommendation there. You just want to assure yourself that you're getting instructions from someone that has capacity. With minors, it's different because minors have guardians. Yes?
I've had situations where it seems to me there was no answer or no solution. I had one recently where a client of mine, an ongoing client, and his girlfriend were living together. They ran out of money for various things.
Mm-hmm.
The girl's mother has property, and she came forward to advance money on mortgages. She referred to the couple as being married,
Mm-hmm.
and that she was giving money for her daughter's house, which wasn't her daughter's house at all.
Yes.
I had them sign acknowledgments, go for independent legal advice. They didn't listen or read anything.
Yes.
There was no understanding at the end of it.
Yes.
And I really didn't know how to extricate myself because the liability of not proceeding was substantial.
Okay.
In terms of damages. They ended up taking so many mortgages on the house that I know there's going to be a foreclosure.
Okay.
Everybody's going to lose all their money. And it's probably going to come back to haunt me.
Okay.
Because I have the paper, but I know they didn't understand what they were saying.
Okay.
They weren't listening to anything that was said.
Okay. Big question here, and I don't know if I have an answer. But just for those watching, I'm going to just repeat your question. Question is, what happens sometimes when it seems like there's nothing that you can do? Where you try and explain something and it's not understood. In this question, in this example, the client was a boyfriend and a girlfriend, and they owned a property. They wanted to take mortgages out on this property. They were not married. They got funds from the girlfriend's mom. Girlfriend's mom comes and meets the client and says, "Oh, they're married. I'm gonna provide funds or sign off here or whatever." And the lawyer says, "No, they're not married. And by the way, I want everyone to get independent legal advice because you're not understanding what I'm trying to tell you, and that you're over mortgaging this house. It's all going to come back to bite you." And they say, "Yeah, sure." They don't get independent legal advice, and they continue with the transaction. To protect yourself in any situation, document and send yourself a letter to the clients. I don't recommend this course of action. Here are the reasons why. Here's how this can get back to you, and so on. And when that bad thing happens, then you say, "I did everything I could. Here's the letter I wrote." When you are trying to write a letter like that, what I would love to see is you to set out these things: the possible outcomes, the risks involved with each outcome, and the costs involved with each of those, and timing. So if you can put those 4 things into your letters, right, that will protect you. If you can docket that, even if you didn't have time and you do 100 transactions a day, if you docket, discussed possible outcomes, risks involved with each outcome, costs involved with each of those, and timelines, that helps. Because 3 years down the line, you're not going to remember what was said and done. But that letter that you write, that docket that you write, using these 4 words, and that's why I keep repeating them, possible outcomes, risks, timelines, and costs, then that will help, that will go a long way. Otherwise, sometimes you just watch bad things happen. Thank you very much. Okay, so where time is up here, you want me to say this, Chris? Oh, we got one more question. Okay, we're gonna have some more fun here. Wondering about the CRA letter, the lien example I started you guys with. Could I please have the name of this case, which is currently going through the courts? I don't have that available here. If you send me an email offline, I will see if I'm allowed to give it, but we have privacy policies. So send me an email and we'll figure it out. My email is ian.hu@lawpro.ca, or give me a call. You guys just call into LawPro. I'm happy to talk about it within our privacy policy. So we're going to break now until 11:15 and return with our fraud, cybercrime, and real estate risk management. Thank you very much.